this is for the Zoom people. Generally, I'm pretty loud. I've spent 30 years in a courtroom, so I've learned to be pretty loud. My name is Chuck Rose. I have a private practice here in Illinois, about an hour west of here. My practice is dedicated almost exclusively to helping families with children with special needs. And when I say children, I'm talking about 18 has nothing to do with it, okay? So I probably really should say families with family members with special needs. So I do everything from estate planning, which obviously includes a special needs trust, to guardianships, Social Security, applying for and appealing, Medicare, Medicaid, all those things that are needed. Today's focus is on estate planning and a special needs trust. I have been doing this for approximately 18 years. I have found over those 18 years that there's two questions keeping us up at night. Who's going to take care of our children when we pass away? Where is the money going to come from? Because we don't want the people who are taking care of our children for financial burden, okay? And I'm going to answer, those two questions are answered in estate planning with a special needs trust. So let me start with a special needs trust. So that one-page handout that I have given to you, if you take a look at, a special needs trust is a legal device to collect assets on behalf of a family member with special needs and keep them government benefit eligible, okay? Now, I'm going to talk a lot about Social Security because it's kind of the example that we all know. But please understand, when I'm talking about government benefits, I'm talking about all government benefits, up to and including independent living when your child gets older. So we need to keep them government benefit eligible for their lifetime, all right? Especially that part of their life when we're not around anymore, because we want them, they are going to outlive us, and we want them cared for and living a full life after we've passed away, okay? So a special needs trust can collect from three different areas, okay? One is what I kind of call the everyday. Christmas, birthdays, some parents, grandparents choose to fund, they'll do something regular, you know, so much a week, a month of, or something like that. So it can collect all of those assets. The second is when we pass away. We want to leave for all of our children, and the special needs trust allows us to leave for all of our children, okay? Meaning that if we have more than one child, the standard practice is for parents to tell me, Chuck, I want to leave equal shares to my children, 2, 3, 4, however many children, all right? And obviously that's inclusive of their child with special needs. So they'll tell me they want an equal share to that child as well, which they should be allowed to do. They've earned the right and the ability to do that. So with it left to the special needs trust. So if there's Johnny, Timmy, and Gloria, Johnny and Timmy are named specifically, Gloria is through her special needs trust. But we get to leave to that, okay, and keep them government benefit eligible. The third area is family members, grandma, grandpa, aunts, uncles, siblings of theirs. As they get older, I've now on the second generation with the siblings wanting to leave for their brother, sister, because they've gone to college, they got a good job, now they want to leave for them as well. So they can leave, they can do an estate plan and leave to the special needs trust and have their family member government benefit eligible throughout their lifetime, okay? There are two kinds of special needs trusts. One is the one that I've been talking about here, the one that's most applicable is called a third-party special needs trust. I got to sound like a lawyer at least once. Third-party special needs trust simply means assets that are not the child's, okay, or not the family members. That's the one I've been talking about. A first-party special needs trust is assets that are already in the child or family member's name. All right. So those were traditionally set up for personal injury settlements, medical malpractice settlements. So if any of those, if that situation arises, those monies can be left to the first party special needs trust. Everything else is the same. Actually, let me explain so that you guys understand. So a special needs trust, when funded, can be used for the supplemental needs of our child. That's Social Security's definition. Okay, not very helpful. I've developed a list over the years, but basically what it comes down to is everything that puts a smile on your child's or grandchild's face. Okay, so Social Security benefits are used for housing, transportation, medical, those kinds of things. Special needs trust, Disney World, new iPad, those things. The supplemental needs funds can be used for that. Okay, so when I draft a special needs trust, my special needs trust is approximately 20 pages long, 18 of which are the best sleep-inducing device on the planet. Okay, 2 pages are what's relevant to everybody who doesn't want to read those other 18 pages and fall asleep. And that comes down to who you name as successor trustees of that trust. So what I do is I name you as the trustees of the trust. You're in charge of the money during your lifetime, okay? But your child is going to outlive you. So you need to name successor trustees who will take over when you have passed away so that they can keep doling out the money for your child. So that's the first question. Where does the money come from for our children when we pass away? So it comes from that special needs trust. Okay. And then the second thing I need to know for purposes of that third party special needs trust is you've passed away, child's passed away, money left over in the trust. The ideal situation is the money, they use up the money, just as they pass. That's never going to happen. There's going to be money left over. So you tell me, you direct me where that money goes. Okay. Now, let me explain the difference between the first party trust, and that is this, where I told you, you tell me where that money goes in a third party special needs trust. In a first party special needs trust, all goes to I shouldn't say that, goes to the government. The government is handout, goes first. Okay. Any government agency who has extended government benefits to your child or grandchild gets first crack at the money that's left over in a first party special needs trust. Okay. In a third party special needs trust, that is simply not true. All right. So I'm obviously using a third party special needs trust for what is standard, what we need to do. I only mentioned the first party trust to let you know that it is a device that allows you to do the same thing, protect your child or grandchild's government benefits, and keep them government benefit eligible in the event that they get assets in their name. Okay. So that's how the special needs trust works. Now, the special needs trust is a standalone special needs trust. And I'm going to say that again. The special needs trust has to be a standalone special needs trust. The reason that I repeat that is that if you've gone to an attorney to draft a special needs trust and they're not quite fluent in this particular area, what they'll probably do is what's called a testamentary special needs trust. All right. Now you're convinced I'm a lawyer, right? Because I just used that word. Fancy language for a trust within a trust. So if you do a trust, which you will have to do for your estate plan, a testamentary special needs trust is a trust within that trust. You with me? So the reason that I bring it up is because that testamentary special needs trust that's in your trust does not come into effect until you pass away. So I've already told you where money can be collected. It's not going to work in a testamentary special needs trust because it doesn't exist. So if grandma and grandpa leave a bunch of money to our children and in a testamentary special needs trust, doesn't do anybody any good. Now the child has more than $2,000 in assets and is no longer government benefit eligible because it doesn't exist. We're still alive. Okay. With a standalone special needs trust, as soon as you sign it, it's in existence. Okay. So it can collect in all of those areas that I just talked about. So it's really, really important. Okay. So if you've done one, go home, find out if it's testamentary or standalone. Okay. And my recommendation is if it's testamentary, then you're going to need to go somebody to get a standalone special needs trust. I have never, ever done a testamentary special needs trust in my life. And I've been doing this for a long time. All right. Yes, ma'am.
Testamentary needs trust also called a trust by the will or something like that.
Sure. Yes. Yeah. Probably, you know, there's all kinds of different language out there. But yeah, I'll bet that could be, that would certainly be a red flag to me to say, I better take a look at that. I do a lot of presentations. Yes, sir. Okay, gotcha. So the question was trust by will. Is that a testamentary trust? Yes, probably. Okay. So I do a lot of these presentations and I'll always say to the participants, if you've got the estate planning trusts already drafted, I'm glad to take a look at them and advise you as to whether you have a testamentary trust and what you need to do from that point on. Okay. Which means mostly I'm not generating anything for me. Mostly I'm sending you back to the attorney who did it in the first place to get it right. Okay. Because obviously the most important thing is to protect all of our children. Okay. But the added requirement of really protecting our child with special needs, especially for that time when we're not here anymore. Okay. We really want to do that. All right. So the special needs trust is part of a greater estate plan. All right. Because you've got to leave to your children. And the only way you're going to leave to your children is if you draft your own trust or will. Okay. So you will say in your trust, I leave equal shares to my children. What I'll do is spell out your children individually and then name the child with special needs. I'll name their special needs trust. Okay. Little extra language. Not a big deal. But then we guarantee that the assets that you leave for that child go into the special needs trust. Okay. So let's answer the second question. All right. The estate plan, you will have a trust or a will. You, not a special needs trust, you will have a trust or a will. If you come to me, it's highly unlikely that you'll get a will because those are old and outdated documents that just don't work anymore. So you get a trust, okay? In that, the estate plan, in that estate planning document is wherein, and in the only place wherein you can name who takes care of your child in the event that your child hasn't reached the age of 18. Okay, so that's that guardian provision that says, in the event that my children have not yet reached the age of 18, I want so-and-so to be guardian of my children until they reach the age of 18. In the event of a child with special needs, I put in a provision that says, in the event that I get successor, that the parents obtain guardianship for their child, then we want this person to be the successor guardian on that guardianship. And that's the only place. So now you've answered both of those questions. Who's taking care of my child and where is the money going to come from when we passed away? All right. So that's why I really want to emphasize the fact that a standalone special needs trust is part of, and that's why this seminar is titled that, part of a greater estate plan. I have never once done a special needs trust all by itself. It makes no sense. Okay, just doesn't make any sense to do that. All right, so when I do a special needs trust, there are 3 homework assignments. All right, so I'm going to emphasize these 2 so that you understand. The first homework assignment is that I'm going to tell you that you need to go and get an FEIN number for the trust. Basically, a social security number for the trust. So once the trust is drafted and signed, if I have 2 parents in front of me in my office, now there are 4 taxpayer entities in the room. Me, my 2 clients, and the special needs trust. Okay? It gets its own social security number. It's not the child's social security number. It's not your social security number. It gets its own social security number, which was why they call it an FEIN number, okay? Because the trust, once funded to a certain level, which changes all the time, it has to do a tax return, okay? Because it's a tax-paying entity, all right? So that's the first thing I do. Now, please understand, folks, that does not mean that you have to fund it right away, okay? It does not mean that you have to fund it right away. You can choose to do it with the birthday, Christmas gifts. If you want to put so much money from your paycheck away, certainly do that, okay? And only when it reaches a certain amount does it have to start doing tax returns, okay? And like I said, that changes all the time. Many of my parents wait to fund it. The fact that it has a FEIN number, IRS doesn't care. The only thing IRS cares about is if it's a funded trust, it's not doing tax returns, okay? But that FEIN number can be in existence in an unfunded trust until you pass away, because some of my parents don't fund the special needs trust until they pass away. And a lot of times what they'll do in that case is they'll do what's called a second to die life insurance policy. So they'll pay to this life insurance policy. They'll make the special needs trust the beneficiary of that second to die life insurance policy. And then when the survivor of the 2 of them passes, the trust is funded. And there is the money to take care of the child after they pass away. Okay. So there is that option, and some parents choose to do it that way. Now, if grandma and grandpa's and aunts and uncles leave something to the trust and they pass, now the trust is funded. Okay, which is okay, because it doesn't have to do a tax return until it reaches a certain amount, and it's only on the interest. Taxes is not my area of expertise. If I was good with math, I would not have gone to law school. Okay. But you check with the person who does your taxes, and they can certainly talk you through that. Okay, but I want you guys to understand that. The second homework assignment I do is I send you home with what I call a family letter. It's your letter. I draft it, but it's your letter that says we've just drafted a special needs trust for our child, and if you're going to write a check for birthday or Christmas, here's how you're going to write it. Okay, if you're going to leave something to our child, then this is how you do it. All right. The reason I do that is because we need to identify everyone in the family that wants to leave something to our child with special needs. Because if something gets left, okay, that doesn't name the special needs trust, now you endanger the eligibility of the child for government benefits. I don't want to panic you. There's a way to deal with that, but there's the potential for that, and we want to avoid it. All right. Makes no sense for me to do. It makes no sense for all of us to do all of that work. You get the fancy package and the blue lining and all of that kind of stuff if we haven't done the homework assignment to make sure. Now, the reason we do the letter is grandma and grandpa, usually, that generation keeps their estate plan pretty close to their vest, okay? Usually because their attorney has told them, keep it close to their vest. So the parents don't even know that they have left something to the grandchild. Because I have found over all the years that I've done this is that family members will make an extra effort to leave something, okay? Traditional languages, I leave equal shares to my children with a per stirpes clause. Oh, I'm sounding like a lawyer again. With a per stirpes clause that only means, okay, if my child's passed away, then it goes in equal shares to my grandchildren. That's all. It's just fancy language for if my child has passed, it goes to my grandkids because we want to leave for our kids and our grandkids. Okay, so that's the way that's the standard language. I have found over the years that grandma, grandpa, aunts, and uncles will carve out. They will say, I want to leave a certain percentage to my grandchild with special needs. So as long as it names a special needs trust, that's fine. Absolutely fine. So they'll take that letter to their lawyer because they've already drafted a trust for themselves. And what usually happens is if the lawyer isn't well versed in this particular area, the lawyer will call me because I tell them right in the letter, if you got any questions, call me. And then I just talk the lawyer through it. Okay, so that we can guarantee then that our children stay government benefit eligible for their lifetime. Okay, because that's really the important thing. All right. The third homework assignment is we're going to identify all the assets in the child's name at the time that we do the estate plan. Traditionally, people come to me, 18 seems to be magic. The age of 18 seems to be magic. Now, for purposes of guardianship and applying for Social Security, it is the magic date, no question. All right. But they'll wait to do the estate plan until child's almost 18. All right. The problem with that is, you guys may have heard this, is Social Security has a 5-year look back period. Okay. So if you apply for government benefits at the age of 18, they're going to look all the way back to 13 to see if there were any assets in the child's name that were above $2,000. Okay. So we have to account for that. So we've got to have you guys identify what assets are in the child's name. And then we have to do something about those, because usually what comes on top of it is I'm doing estate planning, guardianship, and applying for Social Security all about the same time. Okay. So obviously to apply for Social Security, I have to have the child government benefit eligible before the application to Social Security. All right. And there's ways to deal with that. But that's part of the homework assignment because we need to know that. I say we because I have an assistant that does just my Social Security stuff. I took a look at it and said, nah, I'm better in the courtroom. I'm not better with government agencies who don't want to work with me. She's great. She's got the patience for that. I just come in when there's appeal process, when it goes to the administrative law judges, when I jump in, because while it doesn't have to be a lawyer, it's better at that point to have a lawyer do that. Okay. Because they're more well-versed in that, especially one that spends a lot of time in the courtroom like I do. So those are the homework assignments for the Special Needs Trust. Again, part of the greater estate plan for you guys. Okay, for you guys. Any questions so far? Yes, ma'am. Okay.
So is that what happens to FEIN number?
Not right away, because it doesn't exist.
And what makes anybody else know you what?
Yes. I have a testamentary special needs trust. Do I get an FEIN number? My response right away, my response is no, because it doesn't exist. The second question was, what if I don't think somebody's going to fund it? Should I do it anyways? My response is yes. All right. And the reason that I say that is based on experience. Okay. The challenge, quite frankly, the challenge for me is trying to anticipate. Let me back up for just a second. Estate planning is challenging because I have to plan for tomorrow and 50 years down the line. Okay? Because conceivably, you could, and quite tragically, you could leave my office and be in an accident. All right? More likely, you're going to live for 50 years. Not me, but you guys. Okay? So you have to plan for that. And within that time span, whatever it is, are a whole bunch of potential surprises that we didn't anticipate. Even though we worked hard to try to anticipate them, we may not have anticipated them. Okay? Let me give you an example. I am pretty thorough about this because I make the promise that I'm going to answer those two questions, right? So I went through this with this very nice young couple. We worked hard and we got it all done. 3 months later, they call up, want an appointment. They come in and say, hey, Chuck, the child that you wrote the special needs, the standalone special needs trust for, just got a $15,000 check from a Native American tribe. And no, we didn't even know our child was Native American. Okay? I'll admit it. I didn't see that one coming. Never saw that one coming. Okay? Now I ask everybody if that's a possibility. All right? So that's kind of a long-winded way of saying I don't like surprises with a special needs trust in standalone special needs trust in place. You don't need to worry about the surprises, potential surprises that can come down the road. Okay. Plus, the other thing about a standalone special needs trust is let's start with this. Social Security hates them. Nobody here from Social Security, right? Social Security hates them. Okay. So there's always that concern about, because they're always lobbying Congress. There's always that concern. They finally come to the realization that they're going to exist. Okay. Because before special needs trust came along, you only had two choices. One, disinherit the child, make them a ward of the court. Or two, give all the money to a sibling. And I could regale you with the horror stories about that. The number one being the child got divorced and half of the money you left for your child with special needs went to the divorcing spouse. Okay. That's what really was the impetus for special and several other things for special needs trust. Okay. Because even Congress had to recognize, even with Social Security screaming in their ear, hey, no, that's not the right way to handle that. Okay. So they're going to exist. But the thing is, Social Security is always lobbying to try to make it almost impossible to use them. Okay. So with a standalone special needs trust, are grandfathered in. They can't do anything. They can change the law all day long. But at the time that the law exists, at the time that I draft it, it's good. Testamentary trust, remember, doesn't exist. It does not exist until you pass away. So it's not grandfathered in because it simply doesn't exist. All right. So that's the other reason that I like that standalone special needs trust in place, because now it's golden. Because right now is a good place for those. Social Security now, they're fine with my third party special needs trust. They'll fight me a little bit on the first party trust. Okay. They hate those even more because the child's received a $500,000 medical malpractice settlement and the taxpayer is paying for that child's date of death. But even with the first party, as long as I've been doing it, they now concede that, because there is a ton of hoops to jump through in order to get it approved. But also, all of that has to be in place. All that required language has to be in place for it to be valid. Okay. I've been in front of an ALJ where on an appeal, and Social Security has said on page 17, there's an and in the third paragraph. That's why we rejected it. Yeah. That's how nitpicky they can be. All right. But at least I've gotten to the point now where they leave me alone. I've been doing it for a long time. So they've seen it. So they just concede the fact and they approve the first part. They don't even look at the third part anymore. They're fine with that. There's not as much as requirements as a first party special need trust. So I hope that. No. So a question I get a lot is, there are situations where I could draft two trusts. Okay. I'm going to draft the third party trust because it's standard. You got to have it. If you're going to leave money to your child, you got to have it. All right. But then something happens. Personal injury, medical malpractice. I've used them for like the Native American situation. Okay. So you can have two trusts in place. So the one and only test that I'm going to give you guys is, which one are you going to spend money out of first? Who doesn't want to get, who wants to pay the government for Social Security? The first party. Okay. The point being is that you can spend out of the first party special needs trust and deplete it. Okay. A third party special needs trust can exist with $1 million in it. Nothing the government can do. Okay. And please understand, I am a stickler for the rules. So this is not a gray area. Okay. This is black and white. First party special needs trust funds can be used first, right in the law. They call them, for Social Security, they call them the POMs. It's right in there that it could be used first. So in those situations where I do it, the parents spend out of the first party trust first and deplete it with a third party that exists, because they get to direct where the money goes from the third party trust. Okay. And what they usually do when they direct, now you have choices where you direct that money. You can direct it to their siblings. You can direct it to who was the trustee for the time and effort they took to be trustee. But a lot of times what parents do is, there is something that the child really enjoyed. Okay. Working at the animal shelter. So they leave it to the animal shelter. Park districts. Child really had fun with park district activities. So they leave it to the park district. Okay. Because it's really the child's money. That's what the reason it was put into the supplemental needs trust in the first place. So so parents like to do that. Okay. Or they'll leave to a foundation, which means that every year money is spent out of this foundation account in the name of the child. So now they have a legacy, which parents, we all get a real kick out of, that our kids are able to do that. Okay. So those are the things that you can do from a third party trust. Yes.
You have a recommended amount for third party trust?
Do you have a recommended amount?
Yeah.
For what?
Say you don't have a ton of money. I want to give your other kids more, maybe. You can imagine my older kids who are needing more money than my special child. Not that I want to up to.
Yeah. So this, I'm going to repeat the question. Can I choose to leave unequal amounts to my children? Because I have said most of the time, parents say, I want to leave equal amounts to my children, all my children. Yes, you can. Okay. You can choose to leave any amount that you want, or percentage, because most of the time parents aren't going to leave amounts, they're going to leave percentages. Okay. So 4 children divided by 100, but they lower the amount for the special needs child, or they increase the amount for the special needs child. Because I have found over the years that a fair portion of the time, the other kids will say to mom and dad, we're fine. All right. We had the ability to go to college, get an education and a good job. So we want you to leave more for our brother or sister with special needs. You don't have to, but I find that that happens probably more often than not, okay? But the long-winded answer to your question is, yes, you can leave unequal amounts. Now, the amount or the recommended amount, I can't answer that question.
I have a-
If anybody in here thinks that somehow getting a law degree makes you smart, let me dispel that notion. There is no I have been doing this far longer than most attorneys in this particular area. And I have never in 18 years recommended an amount because it's specific to you. You know what your child is going to need later on in life. Later on in life, they're probably in independent living. Maybe they're working at a day program or something like that. Well, the child's going to outlive you, right? Oh, is he going to live with another brother or sister? Oh, okay. All right. In a group home. Okay. But as you know, traditionally with a group home, Social Security is paying that and they get $30. The child gets $30. Mhm. Right. Right, right. So you're making my point is your child has that particular situation and you can fairly easily figure out how much money that child needs. Okay? No. I'm sure he or she is. All right? Because he probably gets that question fairly regularly. Well, remember, you can always choose to do a life insurance policy that amounts to 50,000. Now, I'm not recommending 50,000 by any stretch of the imagination. You have to do the math to figure out what it is that you want to leave for your child. And you usually, like I said, end up leaving percentages. All right. But I don't make that recommendation. Never going to make that recommendation. No. No. Oh, I'm sorry. Can you fund the third party trust with first party money? That's the question. So let me add to the question a little bit. First party money is, I think what you're asking and the situation that I run into. So let me help you with this. All right. Your child we're successful and your child starts collecting Social Security. So as you know, Social Security will tell you got to do a rep payee account. All right. Because they're not going to write you a check. They'll just direct deposit in the rep payee account. Okay. So that account plus income, child's income. Okay. If they're working, they're in a day program, whatever, even if it ain't much, it's still going into that account because that's their asset. That's the account that you have to keep under $2,000. Okay. We all know that too. We have to keep that under $2,000. All right. So no, that work or Social Security cannot go in to a third party special needs trust because that's an asset of the child. Okay. Now that account collects that money, keep it under $2,000. Over here is a special needs account. There is no limit on that one. Okay. You can put as much money in there as you want. All right. Depending on your circumstances, you can put as much money in there as you want. Because remember, you direct what happens when it gets what's left over anyways. Okay. So at that point, you'll have the two accounts. Okay. Now, that being said, I don't want to overcomplicate this, but that being said is, so we set this all up and that is the way things go. Okay. Things go along. Parents get used to paying for their children. Okay. Their cell phone bill, their, those kinds of bills. With a child without special needs, they usually quit at 18. They'll tell the child, look, go get a job, do whatever. You're going to start paying for your own phone. They don't even think about that with their child with special needs. Never even occurs to them. They just keep right on paying that. Okay. So what happens is they're not spending any money out of this account, and all of a sudden it's screaming up on $2,000. So I get a phone call that says, oh no, Chuck, we're screaming up on $2,000. Okay, so there is a way to do that. There is, and so this is what I do. First, I tell the parents, do a budget, figure out what it is that you're paying for your child. Okay, if you're paying that cell phone bill and everything else, stop doing that. Make the child pay for it out of that particular account. That'll help to lower it. Worst case scenario is I tell the parents, your child just became a renter and you a landlord. Okay, so now they're paying for, let's say that's it's the two of you and the child in the house. Now, three of you are splitting the expenses of the house, mortgage, homeowners insurance, all of that kind of stuff. All right. So you pull out that money because now your child's paying you rent. Okay. That rent money can be put into this special needs trust. Okay. But, and this is a very big but, this money is income to you. And you have to declare it with the IRS. So you really got to crunch the numbers in that case, all right, to see if it even is what you want to do. In most cases, the parents will tell me that what they did was they did the budget, figured out they were paying all kinds of stuff for their child, and just started having their child make those payments. And they were able to keep it under $2,000, okay? So they don't run into that situation. All right, so that's a long-winded way of answering that question. All right. Any other questions? A what? Never heard of it. Never heard of it. Pickle amendment. Somebody called my child a pickle amendment. I slept. Oh, I'm kidding. All right, so let me think. I think that I've given you really the basics of a special needs trust and estate plan and how it applies, well, really to all your children, but certainly your child with special needs. Very, very important, okay? Roughly 15% of the population has a estate plan. And the reason they do that is because they'll all say, well, Chuck, we don't have anything, so we don't need an estate plan, okay? And what I always tell people is, now remember, I'm an attorney in Illinois. Springfield, which is our capital, there's an estate plan ready for everybody. And they get a third off the top. So they love it when you don't do an estate plan, okay? However much. So I want you to stop thinking that estate planning is about having stuff and assets, and it's about protecting your children and making sure that what you have, whatever that is, goes to the children without interference from the state and really anybody else, okay? Doubly important in the case of, you know, a child with special needs, because you need to, we need to keep them government benefit eligible. Because in addition to Social Security, sure, it's a monthly check, okay? But remember, in addition to Social Security comes health insurance, okay? Maybe we can cover our kids to the age of 26. Maybe even less so. We can keep them on our work health insurance because there's a little footnote in the clause that says, if you have a child with disability, we'll cover that child for as long as you are employed with us. Okay. I've read a lot of insurance policies that are almost as good as putting me to sleep as legal stuff. But if you find it in there, then they're going to be covered. But in most cases, our children need to have health insurance, especially when they need to have health insurance, period. But especially when we're not around. Okay. So we have to, so in addition to that monthly check, comes the health insurance 2 years after we start Social Security. All right, so keep that in mind too, the importance of that. Government benefit eligibility is not confined simply to Social Security. There are a lot of other things that might be specific to our children that they're going to need. Okay. And there'll be an asset limit on those, whatever they may be. Okay. You would know if you were guardian because you would have had to go to court to be named guardian. So if you didn't go to court and you're not named guardian, then no. Unless who you're thinking of may not be able to get the job done like you can get it done. All right. The reason I say that is, here's the deal. When our children with special needs reach the age of 18, they're an adult. Period. In the eyes of the law, they're an adult. Period. Okay. So they have all the rights and responsibilities of an adult at the age of 18. Okay. Now, I don't know any 18-year-old that's ready for that special need or not. Okay. But the way to keep staying mom and dad is guardianship. Because now, in the eyes of the law, there's a guardian. Okay. That's the law. That's the black letter of the law. So if your child ends up in an emergency room at over the age of 18, you're waiting in the waiting room. Okay. Technically, you're waiting in the waiting room. Same doctor that they've been seeing forever is going to tell you, you're not coming in. Your child's 18. It doesn't matter whether they agree or not. You're waiting in the waiting room. Technically. All right. I have found over the years that those are played a little loosely. All right. You end up in the emergency room with a child with special needs, they're going to talk to you. Okay. You're the doctor that's been talking to that child forever is going to keep right on talking. Okay. But if you passed away and now a sibling is in charge, maybe not. Maybe not so much. Okay. The emergency room, because the doctor's worrying about their license, they're definitely going to tell them to wait in the waiting room. All right. Now, it doesn't mean that they can't apply for guardianship when you pass away. You don't have to be, the parents don't have to be guardians, okay, in order to establish somebody else as a guardian. All right. It's easier, but you don't have to be. Okay. I've done plenty of cases where sibling has come in and said mom and dad passed, or mom passed a long time ago and dad's passed. And my brother, you know, they asked me to be in charge to take care of my brother when he needed help. And I'm not having as much luck as they did doing that. So we petitioned for guardianship to get them named guardian, because they get those magic letters of office. All right. It's a magic piece, 8.5-inch piece of paper with an embossed stamp on it that tells the world I'm the guardian, which means I'm getting in the emergency room, I'm getting in the doctor's office, I'm getting anywhere I want to be because I'm their guardian. Okay. No, not at all. My assistant, does that impact, does guardianship impact Social Security? No. But my assistant has told me we've now set up a routine. When I told you guys that everybody comes in at the age of 18, we start with the guardianship. I get that established, and then she tells me it's easier to convince Social Security because the guardianship paperwork says that the person has a legal disability. So she can use that with Social Security, saying, hey, a judge said they've got a legal disability. Do not deny this. Okay. So that's the way we do it. So the answer is no, not technically, but in that respect, yes, a little bit, but it certainly doesn't affect their benefits or health insurance or anything like that. None, nothing. Okay.
party trust. And grandparents or savings get poured into that trust, and that child passes away before any or my husband do. Obviously, so we could leave it to like foundation, other things like to draw, but I mean, what if there's a large amount left?
In the event that I have a funded trust with lots of money in it, and the child
And
passes
the child
before you do, there's a provision in the trust that says basically that the money is yours. Okay. The trust, two things. I can do this real quick. Amongst the many other criteria, a special needs trust has to be irrevocable, which means once it's in place and signed, the only two things that can end that trust are child passes away, money runs out. Child passes away, the special needs trust is revoked. Okay. All right. Now the question the question I get a lot, I get that question a lot. The other question I get is, what if my child never collects a dime in government benefits? Pretty rare. Okay, pretty rare, especially when we're thinking long term. In that event, what I do is what I recommend, standalone special needs trust. Okay, because we're keeping government benefit eligible. Doesn't mean they got to collect government benefits, but we're keeping them eligible. But in the event that they get into middle age and never collected a dime in government benefits and they're doing fine, a couple of choices. One is you can turn it into what they call a spendthrift trust. All that means is you're putting a trustee between them and the money. Okay, so your sister, you've named her as trustee. Now she can spend that money on anything. There's no rules because the child isn't collecting government benefits. But, or you can just give it outright to the person. Okay. I usually lean towards the side of a special spendthrift trust because you've got somebody, you got a trustee between them and the money. All right. But understand that they can give out that money for any reason. And usually you tell them in your letter of direction how you want that money spent. Anybody else? It's the last chance. Okay. All right. Thanks, folks. Thanks for coming. I do truly wish you all of the best. If you have any questions, I'm going to guess that a fair portion of you are not residents of Illinois. Okay. If not all of you are not residents of Illinois. Okay. So what I'm going to recommend, here's what I'm going to recommend. Number one, if you don't have an attorney, you can go to the Special Needs Alliance website. They have a list of attorneys state by state. Okay. All right. Pick off of that list, please, because somebody might be out there hawking themselves as an expert in this particular area, and they may not be. So go to that particular website. If you don't have one already, especially if you're not comfortable with, please understand that the single greatest criteria for hiring a lawyer is you got to be comfortable with them. Okay. All right. So if you go to one you're not comfortable, look to the Special Needs Alliance website. All right. That being said, I've all given you a handout. It's got my email and phone. You can call me anytime you want. All right. And I will answer your questions. I will talk you through something that's come up. I'm just not going to be your lawyer. I'm just going to be the guy that has a little bit of knowledge in this particular area and can help you with it. Okay. All right. Thanks, folks. And you what? Yeah, absolutely. Yeah, absolutely. Yeah, absolutely. And if you want to scan an email, if you got a trust, special needs trust that you would like to scan and email to me, I'm glad to read it, give you advice on whether it's a good one or not, and I do not charge for that service.